The concept of notice and consent is something very unique to India. The reason being, as Indians, Indian organizations, we have never really given our consent for data usage or consent, informed consent. These terms are something which, though are existing in the law in India, especially let's say even in the cases of medical services being provided, in actuality, the implementation of this is really not happening. So if you look at the Indian population, though we know the term consent, we understand we should be notified of everything, but it's never really happened that our consent has been explicitly taken for services being provided to us, data being processed of ours which we are providing. For example, today you give data to a bank for opening your bank account. And, allied insurance companies, medical companies start providing you offers who are, somehow in alliance with the bank. The data is being shared across multiple specters, and that is the whole concept of marketing in India. Digital marketing, business analytics, business intelligence. A lot of these terms are surrounding around data usage of data principles, data subjects like you and me. And most of the times our consent for this data usage is never taken. Now, the EU GDPR laid down the foundation of the concept of consent. The Indian data protection law has further solidified it for being applicable to all people residing within the territorial boundaries of India. So, what is the provision of consent and notice outlined in the Indian data protection law? Now, when any data fiduciary, that is the person or the data controller who is collecting the data and deciding how this data is going to be processed and for what, prior to such collection of data, he has to give a notice of consent to the data subject or the data principal. This particular data subject or principal, the notice that is received has to be very comprehensive, mentioning why this data is being collected, how it will be processed, for what is it being collected. In the event the data principal wishes to withdraw consent, how can he withdraw consent? The rights of a data principal, there is a plethora of rights, a list of rights literally that are mentioned in the Act, and these rights have to be informed to the data principal. How he can exercise these rights? There has to be a link provided whereby he can get back to the data, a fiduciary with respect to exercise of his rights. And the last part in the notice, that in the case he wishes to complain against the data fiduciary, there has to be a provision provided as to how he can complain to the data protection board, the link for that particular platform of the data protection board, or whatever details of the data protection board, being able to empower a data principal to even complain against the data fiduciary. The data fiduciary has to provide these details in the notice. Now, once all these details have been provided in the notice, the data principal can make a rational call, a well-reasoned decision of whether or not he wishes to share his data. In the event he wishes to share his data, then in that situation also, the data fiduciary has to make it very clear for what purpose he has collected. He cannot collect data for purposes beyond the services being provided by him, which is what we call the concept of purpose limitation. So he needs to collect it for the purpose which he has taken consent for. Now, this consent that is being given, or the consent form notice which is there, it has to be very clear, granular, unambiguous. It cannot be within 30 pages of some service agreement or some kind of terms and conditions. There is a clause put in of consent. No, it has to be separate, clear, completely unambiguous, easy in a language of English, also the regional languages. So it also specifies other Indian languages which are there in the constitution, which are the regional languages. So it should be there in all these languages. So any person who is viewing the consent form should be able to understand what he is consenting to. Now, the next question that arises is, what happens to the data which was already collected prior to this act coming into force? So for that data, direct deletion of the data is not required. What has to be done is that the data fiduciary has to now take consent, issue notice of consent to all the data subjects or the data principals. And in the event they give their consent, you can continue processing or using their data. In the event they don't give your consent, they don't give their consent, then in that situation, you need to process to erase their data. So this entire activity also has to be undertaken by a data fiduciary. So this is basically the entire concept and part of consent. Another pertinent point to note is, in the event the data principal withdraws consent any time during the process of processing of data or any time post giving consent, the data fiduciary has to notify all the data processors of such withdrawal and in effect has to withdraw the data or collect back the data, ask for deletion of the data at the data processor's end. So this entire responsibility is resting on the shoulders of the data fiduciary. Another important aspect of the Act is the role of a consent manager. So a data principal can act through a consent manager in order to give consent, withdraw consent, initiate further action with the data protection board against any data fiduciary. So a consent manager is basically an individual qualified, registered with the data protection board who would be able to represent the data principals. There are some situations in which the concept of consent does not apply. The first situation being where the state is utilizing data in the case of any medical emergency, health emergency in the nation. Second, where there is any other emergency situation in which the personal data of individuals needs to be accessed in order to safeguard. In the case of protecting sovereignty and integrity of our nation, in compliance of any judgment, decree or order, where a data fiduciary has to disclose this information. The next part of it, wherever the state requires the data fiduciary to disclose in public interest the information. And lastly, the situation in which a data principal has provided their data but has explicitly not said that I am not going to consent to give the data. So it is implied by the nature of service. Like there is a banking service, you are going to give your name, certain information in order to open a bank account. So it's quite implied that you have consented to give that particular data for getting the provision of that particular service at the end of the data fiduciary. With this, we come to an end of this module where in a nutshell, the concept of consent is explained. It's obviously a very vast and extensive concept. However, in a nutshell, this is what consent, notice, and the legitimate uses, which are the exceptions to consent, imply. In our next module, we will be looking into the rights of a data principal.